arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I am
not
not
allowed to
required
make
to
the
give you
record
that
at all, Your Honor?
opportunity, sir.
I'm not allowed to make the record at all? As I just let you did, because some of the issues has been... Some of the issues
told
has
me what
been,
you want to do.
Your
I've told
Honor,
you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing.
Mr.
As far
Brooks,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution.
Mr. Brooks, I direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so we're not talking about the right to testify. We're talking about the closing arguments, correct? We're not talking about testifying, which you already made a ruling on.
I'm not going to delay
you already made a ruling on
arguments
but
of
Your
the
Honor,
parties.
with all due respect,
I will address your further request.
With all due respect, you already made a ruling about testifying. Did you or did you not?
Mr. Brooks.
So we're talking about now, we're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
you
we
can't
are at the stage
tell
of
me
the
I
proceedings
can't.
where it is the state's burden of proof where they get to make their closing argument.
We're talking about me, though.
I understand that, sir, but
I'm going to inform them of the truth.
Right now is delaying.
I'm not attempting
the court's
to delay anything. I'll let you,
with
Your
the
Honor.
Closing argument.
I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues. From my perspective, that is in an attempt
how am I being dishonored?
to simply
how am I being
delay
in
what
dishonor?
we're doing.
How am
So
I being
you are
in
put
dishonor?
on notice. I am done dealing with
How am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have I not preserved my rights?
This further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
you
made my
can
determination.
hold me in contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments,
Apparently
but you do
don't.
not
Apparently
want to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir. And
or I'm going to bring up that.
And see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new day, though, Your Honor. This is a whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury.
Okay,
but you're right. I will wait and see.
Your Honor, it's still.
But I need to get going.
It's still unconstitutional for you to tell me that I don't have the First Amendment right that I preserved, or the Sixth Amendment right that I preserved.
I'm going to have the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be held in contempt.
Opens,
or I'll be held in contempt.
If you insist on making remarks, then I will excuse everyone from this courtroom, and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law? Because I haven't been dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample on those.
What you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now, because you won't allow me to make the record as I've let you do. You've even went so far as to mute me.
Mr. Brooks,
which you can't even, there's no lawful law to say that you can even mute me.
I'm advising you to be quiet. They're coming
Your Honor,
out.
Does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
so
when the door opens, I expect you to be quiet, and you will forfeit
and I
your
expect
right to
for
be
you
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
The jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the mute button.
Records reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether he agrees with them or not.
I haven't dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the way that
not
you have
disrupting
through
the
the course
proceedings.
of
You just
3
told
weeks.
me you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not even
the
in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that the jury. I'm informed that the jury is outside the door.
To be respectful of their time.
They're not in the courtroom. They're not present.
I'm asking you to be respectful of the court's ruling.
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my satisfaction.
record
It's
has
about the
been
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
framework?
servant on why you're making up laws that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button.
can
It
go
never
back
said
to the
anything
jury
about a
room.
mute
Thank you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for your
You
closing
can't invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other courtroom when I can
and
do
you'll
so
mute me,
without
which you can't lawfully do.
Interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment.